Chief Justice Warren Burger once wrote, "The obligation of our profession is to serve as healers of human conflict." Welcome to Lawyers as Healers, a podcast exploring an evolution happening inside the American legal profession. I am your host, Dave Albrechta. I am a coach, a mediator, and a recovering litigator. In this podcast, I'll explore how and why an increasing number of lawyers are moving beyond adversarial thinking to return to the obligation of our profession, which is to serve as healers of human conflict. Hello, welcome back to Lawyers as Healers. I'm glad you came back for episode 3. And in the last episode, I talked briefly about how and why we go to law school, why lawyers choose to go to law school, and how that impacts our work as lawyers as we go. And in this one, I want to focus a little bit more, as I promised, on what law school actually trains us to do and get a little bit more into the training we receive, or in my opinion, don't receive as lawyers. And we'll tie that kind of back into the theme of lawyers as healers throughout this episode to kind of talk about why and how we're not even trained to do the things that I think Warren Burger had in mind when he referenced lawyers being healers of human conflict. So I really want to talk about, how lawyers are trained. And again, all of this is coming from my own experience, and I'm looking forward to bringing on experts and people who do this for a living and professors and hoping to talk to a lot of those types of folks who have much more insight on this than I do. And I'll also note, I haven't been in law school in 15 years, so things may be changing. I hope they are. But all of this that I'm going to say today is based on my experience back in 2010 or 11 through 14. There is no practical requirement to become a lawyer. All you have to do is pass law school and pass the bar. There's no requirement for hours of practice or hours of meeting with clients or hours appearing in court. All of the things that we do on a day-to-day basis as a lawyer, those things are not tested in law school. They're not tested on the bar, and there's no practical requirement to get your license. You just have to pass a bunch of tests. And I find that troubling because that's not what it is to be a lawyer. After you take the bar exam, you never take another test again if you want to be a lawyer for the rest of your life. And being a lawyer is a lot more than that. It's learning how to talk with people and meet with clients and work professionally with opposing counsel, and how to converse with a judge, and how to behave in court, and how to behave in an office with coworkers. And there's all these things. I'm not suggesting all of those should be requirements to be a lawyer, but certainly the core tenets of what our job is, I think, should be. Think of any other profession where the primary role is to meet with clients. Therapist, psychologist, even coaches, going through that right now. In order to get a certificate or a degree in any of these other areas or a license to practice, there's a practical requirement. You have to prove that you did X number of hours in order to get a license to go do that thing out in the real world. And the law has nothing like that, which to me is really shocking and kind of scary when you think about it. And that's not the only problem. There's also an issue which gets kind of back to the purpose of this podcast, which is the lack of information that we are taught. So not only are we not required to do practical training, we also are not taught basics about human conflict, which I think is way more problematic than the practical piece, the missing practical piece. And my experience with this is that I took one negotiations class in law school, and my recollection of it was we would kind of reenact and do mock negotiations as a part of class in addition to the final exam. And we learned about negotiating and BATNAs and, all the things that most of us learn about how to be effective negotiators. But that class was all aimed at outcome, as you can imagine. We would come back from those exercises, debrief with the class, and basically rank who did the best. And the people that did the best, or you were given the best score based on what you got out of the negotiation. Did you get what your client wanted and more, or did you not get everything and less? And you would be graded on, how much you got from the other side. Um, and that's fine. There's important skills there, and it's good to learn to be a effective negotiator. And so, that was a nice practical piece of my education. But that's as close as I ever got to that skill set. In the next episode, I plan to tell kind of my full story about the moment when I realized I couldn't keep litigating, what led up to that, and how that all transpired. But fast forward beyond that, and after I decided I couldn't keep doing this anymore, I started looking at mediation training. And I did 3 different mediation trainings. The first one was with the Colorado Bar Association, and it was a pretty standard what you'd expect 40-hour training. And, however, in that training, I was the first time I was ever introduced to facilitative mediation, which is when both parties, the actual clients, are sitting in the room together across the table and the mediator is helping them have a conversation. And this is a little embarrassing, but up until that point, I did not even know that that was a thing. I didn't even know that there were mediators that did that kind of work. I didn't know that it had a name. I didn't know that people were actually doing this out in the wild in the real world, and it blew my mind. As a employment litigator, we would never even dream of doing that. If I proposed that to opposing counsel, I'd be laughed out of the room. It wouldn't even be something that people would consider. And so my concept of mediation was parties in different rooms with their lawyers. Mediator goes back and forth between the rooms, delivering messages back and forth. And so in that first training, I was like, this is crazy. And it took me that whole weekend plus some weeks after that to really absorb this as an idea. And I was very, very resistant to it. I thought it was crazy. I thought it was too risky. If I had a case that was pending and active, why would I ever let my client talk to the other party unprepared and just have a conversation? I thought that was nuts. And I just couldn't understand it. And it took me a while to just even accept it as an idea. And even at that point, I was like, I would never do this. Then I went to a second mediation training, which was a small training here in Durango that a friend of mine does. And he is not a lawyer and is actually a former pastor and was teaching this more transformational model of mediation where not only, in the bar association version, you're mediating between the two parties, but you're very much trying to get them to a solution and a settlement agreement. This version was even zoomed out more than that in terms of we just want to help people learn how to talk to each other and how to navigate conflict. And if they come to a resolution, great. And if they don't, that's okay too. We've made a lot of headway and they've learned a lot from the process. So once again, this was a big leap for me, and at least I was kind of warmed up a little bit by the bar association training, but this second one was then another kind of shock to my system and was really hard for me to absorb and understand and accept. But I was getting there. I was starting to really see the value of it and understand why this might even be preferable to what lawyers do. Then I went to a third one. This was all in 2024, which was put on by the Center for Understanding Conflict by Gary Friedman. And if you're a lawyer in the space wondering about mediation or wondering about these kind of alternative types of conflict resolution, or thinking about just your own struggles with the litigation system, I highly recommend his book, which is called Inside Out, by Gary Friedman. It's very short, and it's both a nice acknowledgement because you get to read his story and how he left law and how he developed this approach to mediation, which he calls the understanding based model. And, anyways, this training was taught at a Buddhist monastery in just north of San Francisco. And the whole class is done in a yurt, and you stay in this monastery, and you have all of the meals with the monks and the people that are volunteering there. And this was a really powerful experience. By the time I went to the Center for Understanding training, I was very much on board, and I understood these concepts, and I was motivated by doing this kind of work and practicing in this way, and really saw the benefit for clients. So the point of all of this is that in the midst of those trainings, I learned all this new stuff that I had no idea about, and it really, to put a blanket kind of umbrella over it, is kind of the psychology of conflict, how people approach conflict. And there were all these concepts that I had never heard of. And here I am, a lawyer. I think of our profession as one that is based in conflict and conflict resolution, and I didn't know any of this stuff. So things like learning about I statements and basic kind of nonviolent communication, talking about the difference between interests and positions, thinking about reflective listening and active listening, kind of touching on just some basic emotional regulation and how we respond when we're in conflict. And looking back on this now, I think in relationship to this larger conversation about law school and how lawyers are trained, it really blows my mind that lawyers don't or are not taught any of this stuff. And maybe that's changing. I hope that it is. Maybe there's law schools out there that focus on it. Mine didn't. So I'm not saying that it doesn't happen, but I can say that my experience was devoid of it. My practice was devoid of it. And I didn't learn it until I went out on my own and started looking into this stuff and trying to find different ways to approach conflict. And the metaphor that always comes to my mind is thinking about like a surgeon and comparing lawyers to surgeons. And I'm going to stay in the litigation space. So, imagine that your surgeon isn't trained in the basics of how the body heals or how tissue repairs itself or post-operative care. The only thing they're trained is how to cut and fix, and that's it. That's a terrible idea, right? Because everything they're doing, they need to know about the healing process so that they cause as little damage as possible so that the body can recover after that kind of a traumatic incident or occurrence. And so I'm not a surgeon. I've not been to medical school, but I have to imagine, and I did a little bit of research. I believe that surgeons are trained in this stuff. They learn post-op. They learn how the body heals so that when they're making incisions and when they're sewing people back up, they know how to do these things in a way that gives the body the best chance possible to recover and move on after the traumatic surgery. So now let's think about lawyers. Our clients come to us with a traumatic incident. And as lawyers, what we do is we're like surgeons. We cut into the problem and we expose it and we bring everything out and we do discovery and we bring out all the evidence and we do all these processes that expose what's at the heart of the conflict to allow us to get a legal outcome that's best for our client. And that's traumatic. So they've had the traumatic experience. Now lawyers are digging around in it and taking depositions and making people give testimony and doing written discovery, and that they're making them stirring it all back up again. So they have to relive all these things multiple times. all the while the other side's telling them that they're wrong and they're lying and attacking them for new things, and you've got to be really careful about what you say and how you say it. It's a stressful environment, and so people have to go through that. And then, if it goes that far, it goes to trial, and that's traumatic, and people have to sit in front of a judge in a courtroom and maybe a jury and tell these stories again and relive it all again, and that's difficult. And then we get a judgment and we wash our hands and walk away, and that's the end of it. And there's no post-operative care. There's no recognition or knowledge about what we just did to these people and to their conflict. There's no awareness of what we were doing as lawyers and how that impacts people in the moment and in the future. And this isn't information that is absent. We have all of this information. We have science-backed data about how these things impact people and how traumatic litigation is for people. And lawyers ignore it, or I don't know if we intentionally ignore it, or there's, I don't know what it is. I won't guess, but either way, I know for sure that it's not a part of the conversation. The more I thought about it, the more mind-boggling it was to me that we ignore all of this stuff, that it isn't talked about, that it isn't taught to us in law school. We're all training to be in conflict. Our clients are in conflict. The lawyers are in conflict with one another. We're actively engaged in conflict with opposing counsel, and yet none of us are taught about how we're supposed to manage that. We're told, be professional and take the person to lunch, take your opposing counsel to lunch and talk about the case. That's how we're taught to handle and manage conflict in these scenarios. And that's great, and it's good advice, and I think everyone should do that. But it sure is a lot more helpful going to lunch with that person, having knowledge about how to engage in healthy conflict, which is what we don't have. And you can go to lunch with someone every day of the week, but if you're yelling at each other and refusing to listen and not engaging in these basic tools that are proven to work, you're not going to make any headway. You're just going to tell each other your positions and go your separate ways, which tends to be what happens most of the time. So I think we're doing ourselves a huge disservice as lawyers to not train new lawyers in information that we have and we know and that is being used. And lawyers tend to put themselves above this and say, well, we work in court, we're officers of the court, and we do these big important things. And that stuff, those kind of, woo-woo conversations are for people down there that are doing these types of mediations. But that's not what we do. We have a high-powered former judge mediator who, talks to each party in their room and gets a case done. And that's all great. I mean, it's the system we've got. I will take that back. It's not great, but it is the system we have. And I understand that it works in certain ways. But there's no harm in having more information and more knowledge about how people show up in conflict. And more importantly, like I mentioned in that metaphor, having an understanding of what we are doing to people through this process and doing it in a more careful, conscious, and aware way so that people can heal more easily afterwards, which is something we do not think about. It may cross our minds, but we have no idea how to do it unless you're lucky enough to have had this training or, come from a psychology background before law school. This stuff is all a mystery to most lawyers. So I wanted to revisit this, like I said, because I think this is really important and lays some groundwork for why lawyers are the way we are, why we do the things we do. This gets to the heart of being a healer of human conflict. I think right now most lawyers aren't healers of human conflict because they don't know how to be. It's not their fault. It's a breakdown in the system There are some real serious flaws in how we train lawyers, and that can be fixed. The great news is that's a really easy fix. If torts is a required class, and if we all have to learn the rule of perpetuities, we should also learn some extreme basics about healthy conflict and engaging in conflict. That would not take very much time compared to how long it takes to learn the rule of perpetuities, and would not only encourage people to engage in professionalism, but arm them with knowledge so that we actually know what that means and what it looks like in reality. So I think that's all I have to say on this topic for now. I'm really hopeful to bring on some professors and people who know more about this than I do. And if you know of anybody who would be a good fit for this kind of a conversation, please send them my way. You can visit my website, which is in the notes of this episode, to find a form where you can fill out to recommend a guest or submit yourself as a guest. And like I said, in the next episode, I'm going to get a little more personal and explain what happened to me and my experience of realizing that I could no longer litigate, what led up to me making that decision and everything that went into that, and just all the circumstances around it. So thank you again for coming back. Thanks for the listen. I appreciate you. Take care of each other, and until next time.